good afternoon, or good morning. My name is Leo, and welcome back to the seventh installment of the LOMAD animation. Today, we're going to discuss the board panel decision that was released on June 10th, 2025, concerning whether the mandatory penalty under the Workers' Compensation Law, Section 114A, was appropriately imposed on the claimant that failed to disclose the pre-existing condition to his provider. Now, what happened here is that the claimant was involved in a work-related accident and she filed a C3 form where she disclosed having had prior injuries, including the prior workers' compensation claims. However, she left blank the section requesting the names and addresses of prior treating physicians. Despite disclosing these prior injuries on the C3, the claimant failed to inform her treating physician, in this case, about those same prior injuries. However, regardless, this physician ultimately assigned a 50% disability rating and was later deposed. During the cross-examination, the doctor testified that he had no documentation or notation of any prior injuries or workers' compensation claims. He was completely unaware the claimant had a pre-existing back condition or a prior back claim. The only prior medical record the claimant gave the doctor was a 2015 MRI report, which was completely unremarkable, and that the claimant did not tell him this case was considered an exacerbation of a prior injury. Additionally, the doctor testified that his understanding was the claimant had been out of work since March 2020 because her position was no longer available, not due to disability. On redirect, the claimant's counsel tried to cure the doctor's testimony, where the doctor stated that knowledge of the claimant's prior back injury would not have changed his diagnosis, treatment plan, or opinion on the claimant's level of disability. At a hearing, the claimant testified under the cross-examination that she said, in fact, that she verbally informed the doctor of all her prior accidents, including those from 2012 and 2013, and then she just doesn't understand why the doctor lied during the deposition. The doctor also never asked her for prior records, so she just didn't provide them, and they discussed her prior medical history once during her initial intake appointment. When questioned by the judge, the claimant acknowledged that she possesses a full file of her prior medical treatment records, however, that she just never showed it to her doctor. The judge issued a finding that the claimant violated Workers' Compensation Law 114A based on her failure to disclose material facts to her treating provider. This included a failure to disclose a prior injury to the same anatomical site for which she was receiving treatment on the claim. The claimant's counsel appealed, and the board panel affirmed the judge's decision, holding that the medical provider credibly testified that he was not informed of prior injuries, that this constituted a material omission on the claimant's side under the Workers' Compensation Law, Section 114A, and therefore the imposition of the mandatory penalty was appropriate and upheld. And this case shows how important it is to pay closer attention to what the claimant reports to her providers, because it's very easy for claimants to slip, and therefore we could potentially start exploring whether or not we have a claim under the Section 114A. Thank you for tuning in, and see you next month.